Welcome to our presentation today. We're talking about no surprise billing rules for providers. For those of you who followed us and regularly participate, I apologize for the technical difficulties we had on the last couple of presentations. We think that we've got those worked out now, and we will reschedule those presentations for those of you who might like to participate. But moving forward with the items for today. Couple of preliminaries. This is going to be an overview of the regulations, and I'm going to be focusing on the no surprise billing rules as they pertain to providers. There are additional rules that apply to health plans or others, but I typically represent providers, and therefore I'm going to be focused on those that deal with providers. Also, I'm not really going to get into the weeds. Our goal in just the hour that we have here is really to focus on the big ticket items so that you have a good understanding of kind of what the overall view is. So when it comes time to actually apply the rules, sorry, but you probably really do need to get into the regs to look at the regs. Now, another word of caution, the no surprise billing rules are still somewhat in a state of flux due to pending litigation and proposed rules, particularly concerning the IDR process for disputes with payers. So when it comes time to especially look at those issues with the IDR, you're going to want to check the current regulations, or perhaps more importantly, the current guidance that appears on the CMS's website. They're fairly good at keeping you up to date on kind of what those developments are, and of course monitor the ongoing developments. I think that the most recent, as we'll talk about in a little bit, there was a rehearing granted in the Texas Medical Association case, which may further impact the IDR process. As far as written resources, we have provided a couple of written resources for you. I provided an article that I wrote a couple of years ago when the IBR first came out that provides a checklist. It may be a helpful resource as you go through and just make sure that you are compliant. More importantly is the CMS HHS information that they post on their website. They've got a wealth of information that I'll refer to a little bit later on, so it's always a great resource to get to that information. If you did not receive any of the links to the written materials, by all means contact Charles at the address there, and he can make sure that you get that information. Okay, with that said, let's talk about the no surprises billing rules. It helps to put this in context. A few years ago, the government was concerned about situations where patients get hit up with unexpected medical bills. Could be an uninsured or a self-pay patient that receives an unexpected medical bill that's a lot higher than they thought they were going to get hit for. Or it could be an insured patient who suddenly finds out that their provider was out of network, and so suddenly they don't have insurance coverage, or they're being billed outside the scope of their insurance coverage, and they have a huge bill. The legislature, the Congress responded by passing the No Surprises Act, which came out in 2021. That was followed by the No Surprises Billing Rules that came out in 2021. They took effect on January 1st, 2022. So these rules are currently in effect. Hopefully you've been complying with them. There's really, for purposes of today, there's two different parts to the no surprise billing rules. The first part deals with insured patients. It limits the amount that an out-of-network provider or facility may bill the patient and the payer for certain types of services. Now, it's not all services. These no surprise billing rules only apply or impose these limits on emergency services in an emergency facility or non-emergency services provided by an out-of-network provider at an in-network facility, or for certain area ambulance services. The rules also require that you provide a notice of the patient rights concerning the no surprise billing rules. And when it comes to disputes with the payer, between the payer and the out-of-network provider, it provides for an independent dispute resolution process to resolve the payment that is going to be due to the out-of-network provider. It's really that process that has garnered most of the attention through the litigation and the like. Now that's how it works for insured patients. When it comes to self-pay patients, it generally requires that providers and facilities must give the patient a good faith estimate of charges. When we're talking about self-pay patients, I'm really talking about uninsured as well as self-pay, but just for purposes of the discussion today, I'm just going to refer to both of them as self-pay patients. It also requires that you give a notice of rights to those patients so that they understand what their rights are. And if there's a dispute about whether or not you gave them the good faith estimate or the amount has exceeded the good faith estimate by more than $400, then it establishes a patient-provider dispute resolution process where you have a third party determine the amount that needs to be paid. All right, what happens if you fail to comply with the no surprise billing rules? Well, when it comes to insured patients, that's probably where you're feeling the punch right now, because that's what limits your ability to collect from out-of-network providers, out-of-network payers. So if you fail to comply, if you've got an insured patient, it may limit the amount that you can go ahead and collect from payers or the patient. When it comes to self-pay patients, non-compliance, it could limit or deny your payment under the PPDR process if you fail to comply with the rules. Now, at least for the self-pay patients, there probably hasn't been a lot of enforcement action out there, because even though you presumably gave notice to the patients, a lot of those patients either don't ever read those notices or never follow through with the PPDR process. So I really haven't seen much by way of penalties in those situations, which is probably why it hasn't gotten more press. It's probably more in the cases of insured patients where you're dealing with out-of-network, on behalf of out-of-network providers with the payers. That's probably where you're feeling the issues. Now, if there is non-compliance, even if you don't have patients complaining or payers complaining, the state can step in and they can enforce the rules. That could vary by state. The states are given delegated primary enforcement authority under this, and the states have some discretion in how they enforce these rules. If the state fails to enforce them, then HHS does have authority under the statute to come in and implement a corrective action plan and or impose up to a $10,000 civil penalty for failure to comply. To my knowledge, I'm not aware of situations where the federal government has actually imposed these penalties, but I suppose it's possible out there. You need to be aware of it to ensure you can comply. But really, your compliance is probably going to be more important for you just because of your disputes with the patients or the payers through the IDR or PPDR process. All right, let's talk about the requirements. First, let's talk about insured patients. The no surprise billing rule places limits on the amount that you can bill patients, but it only applies to those patients, these rules, if you are insured. And for purposes of these rules, it means that it only applies to certain items or services that are covered under a health plan or insurance that are provided by out-of-network providers and or out-of-network facilities to patients. So it applies to insured patients, these health plans. That generally means most health insurance plans, including individual or group health plans, whether insured or self-insured, private employment-based group health plans subject to ERISA, non-federal plans, church plans, and traditional indemnity plans. Those are the plans that are covered by these rules. It doesn't apply to in-network participating providers. So if you're participating, you don't have to worry about this. It's governed by your contract, not by these rules. This is really designed to set up the rules that apply if you're billing as an out-of-network provider. It only applies to not all services or out-of-network providers, but only applies to out-of-network provider situations where it's probable that the patient's going to get hit up with an unexpected medical bill, because that's really what it's designed to protect against. So it applies to, it limits the out-of-network providers who want to bill if they're billing for emergency services that are provided by an out-of-network provider or an out-of-network emergency facility. Now, for purposes of this rule, the facility means an emergency department of a hospital or independent freestanding emergency department as licensed by the state, which could include urgent care centers. So if you're an out-of-network provider or facility and you're rendering these emergency services, then you've got to make sure that you comply with this. It's going to limit your ability to bill for those emergency services. In addition to emergency services, it also applies to certain non-emergency services that are provided by an out-of-network provider at an in-network healthcare facility. So it may be a situation where the patient goes to the hospital, that hospital's in-network, they think that they're going to be covered by insurance, only to find out that they get a bill from a radiologist or a pathologist who happens to be out-of-network. So now they have to pay for these out-of-network costs. That's what this was designed to protect against. For purposes of these non-emergency services, a facility is defined as a hospital, hospital outpatient department, critical access hospital, or ASC that has a contract with a health plan covering the services provided, including single case agreements. The rules also apply to air ambulance services that are furnished by an out-of-network provider of air ambulance services. In those situations, the no surprise billing rule places limits on the amount that you can collect from both the payer and the patient. Let's talk first about the patient. So the rule says that the patient's cost sharing for those out-of-network services that are covered by the rule cannot be any higher than the in-network level that patient has. So if the patient's cost sharing amount for their in-network services is 20%, then the patient's cost sharing amount for the out-of-network services is going to be 20%. So the first thing you look at is, okay, what is the cost sharing percentage? And it tracks what the in-network services is going to be. But then, okay, well, what does that 20% pertain to, right? Well, the amount to which the cost sharing applies, the recognized amount under the regulations, is determined in descending order of the following. So there's this hierarchy of how you determine what that recognized amount to which the cost sharing amount is going to be applied, what it's going to apply to. The first is if there's an amount determined by an applicable all-payer model agreement under the Social Security Act. So if you're participating in an all-payer model agreement, then it would go by that. If there is no applicable all-payer model agreement, then the amount is determined by state law. If there is no particular state law, then the recognized amount is going to be the lesser amount of either the bill charge or the qualifying payment amount. The qualifying payment amount is a term that has been subject to a lot of dispute and a lot of litigation, but is generally the plan's median contracted rate for the same or similar service or services provided by a similar provider in the same geographic region, adjusted by certain factors that are set forth in the regulations. Those regulations have been updated as a result of the recent litigation over those issues. Now, so that's the cap, that's the limits on what you can charge to the patient. Now, you can get around those caps if you give the patient notice and you get consent from the patient to bill around those caps. So an out-of-network provider or facility may avoid the limits on the balance billing if prior to the services you give a required written notice of the patient rights to the patient and you obtain the patient's written informed consent that allows you to bill above the limits on their cost sharing. Now, you may wonder, why in the world would a patient ever agree to receive a bill for something more than what they're obligated to pay under these cost sharing? Well, it may be a situation where that patient wants to go to a particular out-of-network provider, and the out-of-network provider tells them, hey, if you're going to come to me, this is what's going to happen, and I'm not going to provide the services unless you agree to pay me, out of network on those things to do the consent. So it's possible, yeah, it's possible, but it doesn't happen very often. And even then, even if you do get the patients give the notice and you get the consent, that exception doesn't apply to certain services, including unforeseen urgent medical needs that arise at the time the services are rendered, pre-stabilization emergency services, certain non-emergency services such as anesthesiology, pathology, radiology, neonatology, assistant surgeons, hospitals and intensivists, diagnostic services, including radiology labs, and certain other things that the patient probably did not foresee, that you can't contract or consent around those things. In addition, if you do happen to get that consent from the patient that would allow you to balance bill, you've got to provide notice to the payer that you got that consent to balance bill. In order to contract around or get that consent around that balance billing prohibition, you've got to give the notice and consent. You don't necessarily have to use the HHS form, but that notice and consent has to contain certain elements that are set forth in the regulations, including that you've got to notify the patient that the provider is out of network, that you've got to provide a good faith estimate of the charges, notice that the notice of the out-of-network limits and the like is not a contract, that the waiver is not a contract, that consent is optional, that the patient's not obligated to agree to it, that the patient has their option to receive care from an in-network provider at the facility, and certain information about the services. So you could come up with your own form as long as it tracks the requirements and the regulations, or you can go to that CMS website that I've got up there, and CMS has, or HHS has prepared their own form that you could use the HHS form. All right, so when it comes to billing patients, this is the summary then, okay? Think of the red as situations where those limits on balance billing apply. Those limits do not apply if you are a participating provider or a facility. If that's the case, then you're not out of network, it doesn't apply, and you just bill according to your contract. It doesn't apply to self-pay patients, it only applies to insured patients. Doesn't apply to government programs, health reimbursement arrangements, retiree-only plans, short-term limited duration plans. So certain types of plans are exempted from these rules. It doesn't apply to items or services that are not covered by the health plan. You can still bill outside of that as long as you presumably have to give notice. Items or services that are not provided at or in conjunction with a visit to a facility is defined in those particular regulations. So if you're dealing with any of that, you don't have these limits on the balance billing limits. On the other hand, if you are dealing with covered services and you're an out-of-network provider, and those limits on the charges to the patient, including the cost-sharing amounts that you can collect from the patient, do apply if you are rendering covered emergency services that are provided by an out-of-network provider or an out-of-network facility, or covered non-emergency services by an out-of-network provider at a participating facility. So you generally have those limits apply unless, if they're within the exception, you may balance bill if, again, you notify the patient, you obtain the patient's consent, and you notify the insurer. But even in that exception, there's an exception to the exception that you can't contract around situations for certain types of pre-stabilization, emergent services, things like that. So that's how the rules with regard to what you can collect from the patient apply if you're an out-of-network provider. The rules also require that you give your patients notice of their rights concerning these balance billing rules. Facilities and providers to which the balance bill rule applies must post that notice on the government's website. In addition, you've got to post a notice or in your office advising them, and you've got to give notice to the patients in person, by mail or email, as the patient directs how they want to receive that information. Again, you can come up with your own notice so long as the notice complies with the rules and the regulations, but alternatively, you can go ahead and use the HHS form. They published a form that you can access on that website that I give you on the slides. All right, that's it all dealing with what you can collect from the patient if you're an out-of-network provider. Let's talk about how you're going to get paid from the payers. Well, the total amount paid to the out-of-network provider or facility, including the patient cost-sharing amount, is determined according to, again, kind of a hierarchy. If you've got an applicable all-payer model agreement under the Social Security Act, then you get paid according to that all-payer model agreement. If there is no applicable all-payer model agreement, then the amount is determined by applicable state law. If you have no applicable state law, then the amount you get paid based on the amount that's agreed upon between the payer and the provider during a 30-day open negotiation period. So they have this period to try to come to terms on what you're going to get paid. If that fails, then either the plan or the provider can go ahead and initiate an independent dispute resolution process, which will determine the amount that you're going to get paid. In order to initiate that IDR process, you have to jump through the 30-day open negotiation period first. So if you are a provider, you get notice of denial of payment from the insurer, or you get a lesser payment that you think you're entitled to. You can go ahead and initiate the process by sending the patient this notice of initiating the 30-day open negotiation period. And that gives you time to attempt to negotiate that resolution during the 30-day negotiation period. There's a form that you use in order to initiate that 30-day negotiation period. You can access it there at the link that I've got there on the website. If you cannot agree during that 30-day open negotiation period, then either party can go ahead and request an IDR by filing the notice of requesting that IDR within 4 business days after the conclusion of that open negotiation period. Now, as a practical matter, since it's always going to be the provider who's going to initiate this because the payer already has the money, right? And so they're not going to probably initiate this. It's always going to be the provider almost always. That notice has to contain certain information. Again, you can go ahead and create your own form, or you can go ahead and use the DOL form that's available at the link on the website. So you've given that notice. Within 3 business days after the IDR is initiated, the parties can agree or object to the IDR entity, the third party that's going to be deciding this issue. If the parties, if one of them objects because maybe they think that one of those IDR entities has a conflict of interest or whatever the reason might be, then they can go ahead and do an objection within that time period. Within 4 days after the IDR is initiated, the initiating party must notify HHS of the IDR entity. If the parties have agreed to the IDR entity, if they don't agree to it, then the receiving party's gonna notify, submit any objections to the IDR process, and within 6 days after that process, if the parties fail to agree, then HHS will go ahead and appoint the IDR entity. The parties must pay the IDR administrative fees that are associated with this. The fees were subject to litigation, the amounts, and in one of the cases, as we'll talk about in just a minute, those fees were thrown out, but the HHS has come up with another process for determining those fees that are set forth in updated regulations. If the parties agree on the out-of-network rate while the IDR is pending, then you've got to notify HHS within 3 days after the agreement so the IDR process can terminate. IDR amounts that may be, if you are going to submit that, you can submit it one by one, or you can also submit IDR amounts in batches, and there's new rules concerning how you do that. Within 10 days after that IDR entity is selected, either by the parties or by HHS, then each party submits their out-of-network rate offer. They've got to submit that both in a dollar amount and as a percentage of the QPA as identified by the payer. They've also got to submit any additional information that's requested by the IDR entity and additional information that either party determines is appropriate for, including things like the size of the practice or the facility, the practice specialty, the QPA for the applicable year for the same or similar items or services, or any additional information that the party believes is appropriate that should be considered by the IDR entity. The IDR entity does, or the rules do say that certain information should not be submitted. But I'm not sure they're going to do much about that other than ignore it. At the time you initiate that process, both parties submit the IDR entity's fee. So both parties pay the IDR entity to make sure the entity gets paid, and then the winner at the back end of it gets a refund of the amount that they paid. Within 30 days after that IDR entity is selected, then the IDR entity goes ahead and considers the information that was provided, and they issue a written decision selecting one of the offers based on the following. So this isn't a situation where the IDR entity kind of splits the baby or makes its own determination. The IDR entity is charged with selecting one of either of the offers. So you've got an incentive to make sure that your offer is reasonable to increase the chances that you're actually going to be selected. Now, the criteria that the IDR uses to make that determination was subject to heated litigation. Under the old rules, under the original rules, it was heavily weighted in favor of selecting the QPA amount, but that was subject to litigation, and that bias has generally been thrown out. So the factors that the IDR entity is supposed to consider is the QPA. It's one of the factors they will consider, but not the heavily weighted factor. They can also consider additional information submitted by a party relating to the particular provider's training experience, quality outcomes, market share, acuity of the patient or complexity of the item or services, the facility's teaching status, case mix, etc. So basically the provider, the IDR entity can consider any of that information that they go ahead and submit that's relevant to that determination. Now, as I mentioned, the original IDR process set forth in the original rules was heavily skewed in favor of the QPA and favored the insurance companies on that. It was subject to litigation by the Texas Medical Association, AMA, AHA, and other entities. There were a whole bunch of different suits that came out or decisions that came out along the way. One of them invalidated the QPA methodology as originally proposed and the bias that it created in favor of going with the QPA. And as a result of that, the government has changed the way that it was doing things with regard to the IDR process. They issued new regulations that accommodated those changes from that case. Now, that case was originally decided by the Texas District Court. That went up to the Fifth Circuit. The Fifth Circuit vacated some of the district court stuff, but upheld other portions of it. Just, I think, a couple of months ago, we got word that that Fifth Circuit decision is going to be subject to an en banc further review. So we'll keep you posted on that, or watch for that, because the final result of that still may be pending. There was a separate portion of the cases which held that $350 IDR administrative fee that was originally proposed, that was set aside. Now, new regulations establish a fee structure that's published by HHS. So as a result of that litigation, HHS has amended the regulations concerning the IDR process, and it has proposed other regulations, but those other regulations have not been finalized yet. In order to take care of the situation in the meantime, HHS has issued a whole series of FAQs and other guidance addressing the effects of the TMA decisions. In the meantime, the government has said that they will exercise enforcement discretion in evaluating the parties' methodologies when it comes to actually determining the IDR process. The best guidance that you may have is, right now, you can go to the government's website. There's guidance issued January 14, 2025 that kind of gives you an overview of this whole process and kind of where we are on the IDR process and what the current standards are. So once you've gone through this IDR process, you get a decision from the IDR entity. That decision is generally binding on the parties, absent fraud or intentional misrepresentation of material fact. It is not subject to judicial review, so you can't appeal to the courts. The party who initiated the IDR may not initiate another IDR involving the same party and the same or similar circumstances for 90 days. So they want to try to get all of those claims grouped together at one time so that you don't have a whole bunch of series of these different actions going on with the same parties. Within 30 days of the decision, the loser has to pay the balance due the other party. The loser remains responsible for the IDR fee, and the winner's prepaid back fee is refunded back to the winner. Just this month, in June of 2025, HHS issued additional guidance on reopening the IDR process to address errors. So if you determine that the errors were identified in the process after the dispute closed, then HHS has just issued new guidance on how you can go in there and reopen that to address errors. All right, that's generally the no surprise billing rules, an overview of how it applies to insured patients. Let's talk about how it applies to uninsured or self-pay patients. Generally, these rules require a convening provider, which is the provider who's directly providing the care, that convening provider or facility must determine when the patient shows up or requests care, determine if that individual is an uninsured or a self-pay. For purposes of today, I'm just going to refer to them as self-pay, but it could be uninsured, or they could have insurance but just decide that they want to pay for it themselves. How do you do that? Well, they're supposed to ask the patient if they're covered by a group plan, insurance, or a federal health care program. If the patient has coverage, then you're supposed to ask the patient if they want to submit the claim to the payer or the primary item for the primary item or service. If the patient is uninsured or self-pay, then you're supposed to inform the patient that they may obtain a good faith estimate of an expected charges, and they could get that upon scheduling the item or services or upon request. And the government has taken the position that any request for or questions concerning payment is deemed to be a question concerning the good faith estimate, so you'd have to go ahead and provide a good faith estimate in that circumstance. Now, if the patient's enrolled in a federal healthcare program, they are never deemed to be self-pay or uninsured. Even if they want to pay for it themselves, If they're enrolled in a federal healthcare program like Medicare or Medicaid, then these self-pay rules never apply to them. It only applies to private pay patients. If you need more information about determining what kind of insurance applies to whether or not the patient's uninsured or not, the government has issued some very helpful guidance. You can access it here at this website, and it kind of walks you through on what insurance does or does not make the patient uninsured. So once you've determined if the patient is uninsured or self-paid, then if they are, then you've got to inform the patient about their right to obtain a good faith estimate you provide that notice by a written notice prominently displayed at your facility and on your website, and not only on your main website, but on site in your facility where the scheduling or questions about the cost of items or services may occur. So presumably in your intake or in your billing office situations. In addition, you're supposed to orally inform, in addition to the written notice, orally inform the patient when the patient schedules the item or service, or when the patient asks about the cost of items or services, then you're supposed to tell them about their right to obtain the good faith estimate. That notice must be made available in accessible formats and the language spoken by the patient. So remember, this came out during the Biden administration, and the Biden administration was very concerned about anti-discrimination statutes. And so under the current regulations, you're supposed to make sure that you provide that in the form and the language that the patient can understand. That notice has to contain certain elements, certain requirements. HHS has published a form. You can access the updated form at that address on the website. Presumably that will be the one that you will be using. If the self-pay person requests a good faith estimate, including an inquiry or discussion about costs, remember if the patient even asks about costs, then that's deemed to be a request for a good faith estimate. So you'd have to provide it. Or if you're going to schedule the primary item or service, then you're supposed to provide a good faith estimate. Within 1 business day, you're supposed to ask, so the convening facility, within 1 business day after scheduling or getting that request, the original regulations required you to reach out to co-providers, other entities who are going to be involved in also providing that service, maybe a radiologist, pathologist, or others, and you're supposed to get their good faith estimate and timely provide that to the patient. But that was a real pain. And it caused a lot of blowback. And because of that, HHS has postponed indefinitely those rules dealing with co-providers. So right now, the rules concerning good faith estimates only apply to the convening providers. Of course, the co-provider could also be a convening provider if they're providing the services directly. But you don't generally have to go out and contact other providers to get their estimate to include in your estimate. You only have to include your estimate for the services that you're providing. Well, when do you have to provide that? Well, if the item or service is scheduled at least 3 days in advance, then you've got to provide a good faith estimate not later than 1 business day after the date of scheduling. So if the patient shows up, they want to schedule surgery 1 week out, then you'd have to provide the good faith estimate. If they're a self-pay patient, you have to provide that good faith estimate within 1 day after you scheduled that. If the item or services is going to be scheduled at least 10 days in advance, then you have to provide the good faith estimate not later than 3 business days after the date of scheduling. If the patient requests a good faith estimate, so they don't schedule anything, but they just want a copy of it, then you've got to provide a good faith estimate not later than 3 business days after the date of that request. If the patient requested a good faith estimate and then schedules services, you must provide the new good faith estimate within the time frames described above if the good faith estimate is changed. If there's any change to the anticipated charges, so you provide a good faith estimate, but you decide that maybe the conditions have changed, or it's more serious than you thought, or the charges have changed otherwise, you've got to provide an updated good faith estimate no later than 1 business day before the items or services are scheduled to be rendered. So generally, you only have to provide this good faith estimate if either the patient requests that in advance, and then you've got 3 days to do it, or if the patient is going to schedule services at least 3 days in advance. So they're scheduling services 3 days from now. If the patient just shows up at an urgent care or at the ER, you're not required to provide a good faith estimate in those situations. It's only when you've generally got 3 days to produce it. So it's if they are scheduling it 3 days in advance, or they show up, they want the estimate, you've got 3 days in order to give it. If they want the services right then you don't have to provide a good faith estimate in those circumstances. Now, a convening facility may issue a single good faith estimate for recurring primary items or services. So the patient's coming back to you for a series of services, then you can provide a recurring, a single good faith estimate for these recurring items or services, as long as that good faith estimate includes in a clear manner the scope of the recurring services, including the time frames, frequency, total number, etc. The scope of the good faith estimate may not exceed 12 months. So if you're going to have these recurring services, you've got to give a good faith estimate at least once every 12 months. And if the good faith or if the recurring items or services extend beyond 12 months, then you've got to provide a new good faith estimate. If the convening provider or facilities listed in the good faith estimate change less than one business day before the item or service is scheduled to be provided, then, so you're no longer going to be providing the surgery. The surgery is going to be provided by surgeon X. Then that surgeon X is obligated to accept that existing good faith estimate as its own good faith estimate, unless they provide, they've got time in order to go ahead and provide their own good faith estimate. So if you're a replacement provider, you're going to want to make sure that that good faith estimate that covered the original services, that it's good and you're good with it, because you're going to be bound by it unless you provide advance notice consistent with the regulations. Well, what does your good faith estimate have to contain? The good faith estimate has to include certain elements as set forth there on the slide, including the patient's name and birth date, the items and services by codes and charges, discounts or adjustments, NPI TIN or of the co-provider or facility, if you know it. Again, because those rules have been postponed, I don't think that there's you'd be dinged for that one. Location where each item or service is going to be provided, the list of items or services that required separate scheduling, and certain disclaimers. You can use your own form, or the government has posted again their own sample good faith estimate. You may want to use that. If you want to use the government's estimate, you can access it at that link on the screen there. You generally, as a provider, need to make sure that that good faith estimate is accurate and complete, because you're likely going to be bound by it. If you want more information about the good faith estimates, the government has posted some additional helpful guidance about what the terms are for that good faith estimate. You can access it at that website. That good faith estimate has to be in writing and given in a manner requested by the patient. So if the patient wants it in paper, you give it to them by that. If they want it electronically, so the patient may save it in print, they can get it that way. Orally, they can get it orally if it's requested by the patient, but you've still got to go ahead and provide the request, the good faith estimate in writing, just to make sure that everybody's clear on what the good faith estimate is. It's got to be provided in a manner that's understandable to the patient, including the patient's any limitations on their ability to see or hear, language limitations, including limited English proficiency, communication needs of underserved populations, health literacy and the like. You need to essentially make sure, just like your consents, that the patient really understands what that good faith estimate really means. That means that you may have to involve interpreters, translators, or other auxiliary aids to make sure that you effectively communicate that good faith estimate. That good faith estimate, once it's created, it becomes part of the patient's medical record, and it's got to be maintained in the same manner as the medical record. You must keep it for 6 years and provide a copy of it to the patient if it's requested. Essentially, you need to make sure that you've got that good faith estimate available if there's ever a dispute concerning the amount of it, either a PPDR or perhaps even a contract claim arising out of it. What happens if your good faith estimate contains errors? Well, the errors themselves don't necessarily constitute non-compliance, so you're not going to get penalized by the government as long as you acted in good faith with reasonable due diligence and you correct the information as soon as practicable. But that doesn't necessarily mean that you're not bound by the good faith estimate. If you've got an error, it's kind of your fault, and you're still going to be bound by the good faith estimate if the patient decides to take you to the PPDR process. even if it doesn't have errors. So you can avoid government penalties, but you're still going to be bound by what you put in that good faith estimate. So you want to make sure that that good faith estimate has the required elements. The government has published a very helpful a decision tree for kind of walking you through the steps of when you have to do the good faith estimate, what the timing is of it, to who is entitled to receive it, and the like. So you can access that at the slides there on the screen. All right, let's talk about the PPDR process. If you've got a situation for self-pay patients, they show up. If the total billed charges for the listed provider or facility are substantially in excess for the total charges that were listed on the good faith estimate, that's defined as more than $400 than the expected, more than the expected charges that were listed in the good faith estimate. And then in that situation, the patients can say, hey, I'm not going to pay that additional amount. That's more than you told me I was going to have to pay, and therefore I'm going to go ahead and initiate the patient-provider dispute resolution process, the PPDR process. When factoring whether or not that substantially in excess test, that $400 is factored in, you have to look at the total billed charges, including the total billed charges for all primary items or services and all other items or services that were furnished in conjunction with the primary items or services to a self-pay patient, regardless of whether such items or services were included in the good faith estimate. So your good faith estimate should include all of those other things, right? It should include all that stuff. And if it's not, then you may be in trouble because your good faith estimate may be substantially in excess than the actual bill, and you may be hit up in the PPDR process. In determining that $400 substantially in excess limit, whether it's the actual billed charges are substantially in excess of the good faith estimate is determined by the services that are rendered by the provider, not necessarily by all providers. So for example, if provider A provides services X and Y and provider B provides services Z, the self-pay patient may initiate the PPDR if the total charges for X and Y that were provided by provider A exceeds provider A's good faith estimate. So you don't look at all the providers there, you look at the provider who's issuing the good faith estimate. Substantially in excess calculation includes the items or services that were not included in the good faith estimate. So, you know, the assumption is you're supposed to be including all the reasonably foreseeable services in that good faith estimate. And if you fail to include it and you charge for it, then, you know, your good faith estimate is still going to be dependent upon what you actually put in that good faith estimate, not these outside charges. If the patient wants to go ahead and initiate that PPDR process, they've got 120 days of receiving the bill to go ahead and notify HHS of their intent to pursue that. They've got to pay a $225 fee. If the PPDR entity determines that the PPDR is appropriate because is substantially in excess and they were otherwise timely in their request, they'll notify the provider of the facility. While that PPDR is pending, when you get notice of that provider facility, it's kind of like a bankruptcy state, you are prevented from moving the disputed bill to collections or threatening collections. If the bill is moved to collections, you've got to immediately cease collection efforts. You've got to suspend the accrual of late fees on unpaid bills or amounts, and you can't take any action to threaten any retribution against the patient to obtain resolution of the dispute. So you can't threaten them that I'm not going to provide care for you anymore if you go through this process. So once that process is initiated, you get notice that you're in the PPDR. Within 10 days of the notice to the provider's got to submit to that PPDR entity a copy of the good faith estimate relevant to the dispute. Remember, you're supposed to maintain that as part of the medical record. You've got to provide a copy of the billed charges that are subject to the dispute. If it's available, if you've got the defense, then you've got to provide documentation showing the difference between the billed charge and the good faith estimate reflects the cost of medically necessary items or services, and that there were unforeseen circumstances that could not have reasonably been anticipated by the provider or facility when the good faith estimate was provided. That is the test. That's the standard for determining whether or not you're going to be able to charge that patient in excess of the good faith estimate that you got him. Within 30 days after receiving that information, the PPDR entity goes ahead and issues its decision. Now, the amount that you're going to have to pay depends on what you put in that good faith estimate. If the billed charge, so that service, is included in the good faith estimate, then if the billed charge is less than or equal than the expected charge, meaning the charge that's listed in the good faith estimate, then you've got to pay the billed charge, right? It's less than what you put in there. That's not going to happen very often. If the billed charge is greater than the expected charge and the provider failed to prove medical necessity and unforeseeability, then the patient's only going to be obligated to pay the expected charge. So you're going to be bound by what you put in that good faith estimate. If the billed charge is greater than the expected charge and the provider proves that these additional charges, these additional items that are outside the medical necessity or outside the good faith estimate were medically necessary and unforeseeable, then it doesn't mean you get the full amount of the charges. The patient is only going to have to pay the lesser of either the billed charge or the expected charge if the expected charge is greater than the median rate paid by the payer for the same or similar service in the geographic area, or the median rate if the expected charge is less than the median rate. So you're going to be limited in the amount that you can go ahead and receive if the patient decides to go through that PBDR process. The bottom line is you want to make sure that that good faith estimate is accurate. If the billed charge is not on the good faith estimate, so there are additional charges that came up along the way or you forgot to put in there, then the rules are a little bit different. If the provider failed to prove medical necessity and unforeseeability for these additional charges, then the patient's going to pay zero for those additional items. You didn't put it in the good faith estimate, and therefore the patient's not responsible for it, and you didn't prove medical necessity and unforeseeability. On the other hand, if you do prove that it wasn't in there because the services were medically necessary, but they were unforeseeable, then in that situation, again, that doesn't mean the patient just gets everything that you want. The patient pays the lesser of the billed charge or the median rate paid by the payer for the same or similar services. So you're still going to be limited. The bottom line is, again, for these self-pay patients, you need to try to make sure that your good faith estimate is appropriate. All right, there are additional rules for air ambulances. They're treated kind of as their own. As a general rule, out-of-network air ambulance providers who render services to a covered person, the provider may not bill the patient more than the cost-sharing amount that would apply to an in-network provider, and there is no exception for the notice and consent requirements. There are other specific requirements that apply to air ambulances, which I presume you know if you're an air ambulance provider. Under the no surprise billing rules, there is a complaint process. Patients or others insurers who feel that you're violating the rules, they can file complaints with HHS. HHS will review the complaint and may request additional information. HHS may refer the complaints against the payers to their CMS enforcement process, and CMS may come after you. Remember that although states are the primary enforcement actions, the CMS does have the authority to require corrective actions or impose up to $10,000 civil monetary penalties. HHS has said that they will make reasonable attempts to notify the complainant of the resolution. Remember, these are federal laws. It's possible that your own state law may have their own rules that govern no surprises when it comes to billing. If that's the case, then you generally have to make sure that you're complying with the most restrictive law. So it's important that you consider whether you need to coordinate these no surprise billing rules with any particular state laws, including any state laws dealing with notice concerning fees you may charge, the amount of fees that you may charge, any kind of dispute resolution process that may exist under state law. So you may need to make sure that you coordinate that. If and to this extent the state law provides less protection to patients than the no surprise billing rules, then apply the no surprise billing rules. If and to the extent the state laws provide more protection to the patients than the no surprise billing rules, then you defer to state law and you have to comply with the state law on that one. All right, for additional resources, as I mentioned several times, the government actually has a pretty robust website dealing with no surprise billing rules. You can access those by simply typing in, Googling CMS or HHS no surprise rules. It'll take you to this website. At that website, you can scroll down and there will be a whole bunch of policies and resources for providers, including specific resources for the IDR process for insured patients and other resources, things like forms. There's YouTube videos. There's all of the updated guidance concerning how you handle those IDR processes. All of that's accessible through this website. When you're talking about the good faith estimates for self-pay patients, then again, they've got a whole bunch of resources, including FAQs, those forms I referenced earlier that you can access here, training, all sorts of guidance, the decision tree, and additional guidance dealing with those issues. The government has also done a couple of webinars online that you can go ahead and access. In fact, I heard that they just did one a couple of months ago, but I have not verified that. I didn't have time to go back there and double check to make sure about that. I heard that they did an updated one dealing with kind of the status of the IDR process, but I cannot verify that on my own. All right, that is a summary of the rules. In closing, for those of you who want it, I did include kind of a checklist of some things that you may want to consider doing just to make sure that you're complying with the no surprise billing rules. I won't go through through those here, but they're available on the slides if you'd like to access that. If you have questions about any of this, then certainly you're not the only one, particularly when it comes to the status or what's going to happen with the IDR process. I know I've received some questions about what is the Trump administration's take on all of this. The No Surprise Billing statute, the No Surprises Act, actually came out during the first Trump administration, so I'm assuming that the Trump administration is going to be supportive. The billing rules did come out during the Biden administration, so we don't know exactly how they're going, whether they're going to walk back that at any particular point in time. I suspect not, though, unlike some other regulatory issues where the Trump administration had taken down some of the guidance from concerning the no surprise billing rules is still out there, so we suspect that they will continue to enforce or move forward with the no surprise billing rules. Thank you very much. I hope that's helpful. If you have any questions, feel free to, you can either look for yourself online or you can shoot me an email and I'll try to answer it when I have time. But thank you for your participation.